Thanks, everybody, for coming to one of the last panels of our, now 5-day session. We know you're hardcore if you came on the afternoon of the last day to hear this motley collection of people that are going to talk to you about, I think, one of the most important issues that the worldwide corruption movement faces, and that's the threat that a recent decision in Italy and its behavior in a number of recent foreign bribery cases poses to the enforcement of the Anti-Bribery Convention of the Organization for Economic Cooperation and Development, or the OECD. Those of us who worked on this for a while know in the late 90s, every rich country in the world, save one, could deduct the cost of bribes from their taxes. Bribing an official in Nigeria, bribing an official in Brazil, Japan, wherever was just part of doing business if you were a European industrialized nation. Look, it's not that long ago, 1997, that the OECD, the Club of Rich Nations, issued a notice saying, no, none of our members from now on will permit bribes to be treated as a tax deduction. And then on top of that, they signed a treaty, now to which 44 nations are a party, the 36 members of the OECD plus 8 others, that says, we will make it a crime under the laws of our country if a company or an individual subject to our domestic law bribes an official of a foreign government. So, if an official of Italy, if an official of the United States, a company in Italy, a company in the United States pays a bribe to a Nigerian official in order to get business, they have violated the law of Italy, they've violated the law of the United States, and they're subject to prosecution by the United States, by Italy. It's not a perfectly enforced convention. There's a person sitting in the 1, 2, 3, 4th row back on the aisle who writes every year about the failure of many nations to enforce vigorously the OECD Anti-Bribery Convention in their nations. Gillian Dell, Transparency International, is for those of you who don't know her, right? But look, it's still a big deal. It's on the books, and Transparency International, local organizations in the countries are jumping up and down saying, enforce, enforce, enforce. We were making progress, and then in 2009, was it, a huge bribe, over $1 billion, was paid by a major oil company from Italy, ENI, and a major oil company from the Netherlands, Shell, to obtain the rights to a very lucrative offshore plot in Nigeria. Over $1 billion. Well, thanks to three of the people to my left, all the rest of the people on this panel, the evidence of bribery is now in the public domain. Starting from the far left, we have Simon Taylor of Global Witness. Global Witnesses. If you have any doubt about the evidence showing bribes were paid, go to the Global Witness website and punch in OPL 245 and you will be persuaded. Next to Simon, we have Lanre Suraju, the head of a Nigerian NGO called HEDA, who played such a major role in exposing the corruption that he now finds himself and his family living in a suburb of Washington, D.C., because of threats to his security and the security of his family. And if you have any extra winter clothes, they've just moved here, and I'm telling him it's going to be really cold this winter, not like in Nigeria. You know, I think we live many miles away from him, but I'm afraid I'll hear the teeth chattering of his wife and 2 children if they don't get more winter clothes. How old are one is 7?
11 and 16.
11 and 16.
And Deborah on my right is a retired FBI. Oh, I'm sorry. On your right, my left, played a role in developing the facts of the case. Now, as the facts came to public light, there was possibility it could be prosecuted in the U.S., but a friend of ours, a person we admire greatly, an brave Italian prosecutor, took over the case, because of course it's more appropriately tried in Italy, where E&I is headquartered, tried the case. In the face of overwhelming evidence, the case was not dismissed, the defendants were acquitted. Worse, he is now under threat of criminal prosecution for activities in that case that are, to use a technical legal term that some of you will understand this, nonsense. BS is another way to put it, less polite. And as a result of the criminal indictment, he couldn't handle the appeal, so they brought in another lawyer to handle the appeal, who was on the record as saying the case should never have been prosecuted to begin with, and promptly refused to take the appeal up. So Italy has acquitted these 2 huge oil companies and 4 individuals. So we fear that we've got a problem. And so Deborah, Lanre, and Simon are going to tell you about the background to the case and what can be done. I did a little summary on the Global Anti-Corruption blog of the background with links to some of the documents for those who are interested, and that post links to earlier posts that have things like the English translation of the Italian judgment and so forth. But it's great that you all could come. Thank you so much. And Deborah, your turn. When did you start on this case?
Right after 2011.
Okay.
2012, yeah.
So she's only been on it for a decade, but.
Hello, for those of you, because I see so many friends in the audience, but my name is Debbie Lapravat. I was a supervisory special agent with the FBI for 20 years, working international corruption. And so several years ago, 2012, Simon Taylor came and requested a meeting with DOJ and the FBI, and so myself and DOJ attorney Dan Clayman sat down with Simon as he began to tell us the story of OPL 245. So you're going to get the Reader's Digest version. So what was really interesting is that back in the 1990s, and again, I have a very long history with Nigeria because one of my first cases was trying to seize some of the $5 billion stolen from Nigeria by former President Sani Abacha. I investigated it for years, ended up success of the U.S. and FBI seized $630 million of Abacha's money. In 2020, we returned $311 million to Nigeria. Just this year, another $20 million, and $150 million is still being litigated. And I've been retired 7 years, so it's like slow. The wheels of justice move slow. But back in the 90s, when President Abacha was president, these things were given, the assets of Nigeria were gifted away. President Abacha gave one to his mistress. These are some of the different oil blocks that were gifted to other people, and one of them was OPL 245. It was gifted to a company called Malibu. It was supposed to be for $20 million.
That's right there.
Yep. It was supposed to be $20 million. They actually ended up paying $2 million. Actually to the government of Nigeria to get that oil block. This is Mohamed Abacha on my left and Daniel Etete. So it's interesting because the owners of Malibu Oil were Daniel Etete under a pseudonym and Mohamed Abacha under the name Mohamed Sani. So it was Abacha's son and the former minister of the time, the Minister of Petroleum. So clearly a conflict, right? Mohamed admitted to using a fake name, and as you can see, this is the name used by Daniel Etete to hold their shares in the company. Abacha died under very interesting circumstances in 1998, and so basically Etete comes in and he just erases Mohamed's name, like, I don't need you now, your father's dead, you can't help me anymore, now Malibu is all mine. So now Daniel Etete owns OPL 245, but until it's producing oil, it's not making money for him. So he went out and he wanted to find a buyer. He had several middlemen looking out, trying to get different, like Russian companies, Eni, Shell. So finally, after Abacha died, Obasanjo came in, President Obasanjo. He didn't like Daniel Etete. He took the oil block back. I guess eventually he needed something from Daniel Etete. He gave it back. So again, this is the short version. In 2001, Shell signed an agreement to acquire 40% from Malibu. The government, Obasanjo, then revoked Malibu's license. Shell invested a lot of money into trying to get this up and running. Then Obasanjo gave it back to Daniel Etete, started lawsuits with Shell. By the way, and prior to this, Daniel Etete was found guilty of money laundering. I mean, he's not a good guy, in France. Now Mohamed Abacha gets in the way because now they want to sell OPL 245 to Shell and Eni. And now Mohamed Abacha goes, excuse me, I own like 30% of this. What are you doing? What are you taking this away from me? So to get free title, the government of Nigeria steps in and takes it back and will sell it. But they didn't take it back. They were acting, it's like you have to ask yourself, at this step, what's in it for Nigeria to step in and take back OPL 245? Because it's not their asset, it belongs to Malibu. They did it because people within the government of Goodluck Jonathan, that's including Goodluck Jonathan, their Attorney General, Mohamed Adoke, their Minister of Petroleum, Didzani Alison Madueke, were all getting a cut. So they come in, they step in, they take it over, and the government of Nigeria sells it to Shell and Eni. They open a bank account in the name of the federal government of Nigeria in the UK, and $1.1 billion is transferred into that account. Immediately, this is where things start to get really, well, I'm sorry, they knew who was going to be paid. The Dutch police did a raid on Shell in the Netherlands, and they got all of these emails, and it showed that they knew who was actually going to be paid, that the money was going to be paid to Malibu. All of this evidence was presented in court in Italy. As soon as the money gets transferred in, immediately they start playing shenanigans with the money. A lot of this was leaked by, these emails were leaked by an Italian journalist. So the money comes in April of 2011, and immediately they try to transfer the entire amount to a bank account at a Swiss bank that was run by an Italian businessman, Gianfranco Falcioni, and called Petra Services. So again, if the government of Nigeria owns OPL 245, why did they immediately attempt to send the entire amount to another country, to an account run by an Italian businessman? That bank looked at this transfer and said, you know, we don't think so. We're sending it back. So it's out there for another month or so. They make a second attempt. Malibu runs over to Lebanon, opens a bank account in the name of Malibu. They send the entire amount, $1.1 billion there. That bank also goes, you know what? I don't think so. They send it back. It sits in the bank till 2011, August of 2011. And at that point, they successfully get 801 million out into 2 bank accounts in Nigeria. It's around this time. This is what I do for a living. I follow the money. So after Simon came, the FBI opened an investigation, and I get the bank records, and I start making flowcharts. When did the money go? It went into these 2 bank accounts up in Nigeria. Where is the money flowing? You can see that 53.9 million bought a Bombardier 6000 aircraft. And of course, those are registered in Oklahoma, so I was able to get the registration documents out of Oklahoma. And I start tracing who are these people, people within Daniel Atete's inner circle, his family are getting money. Money also went and bought like a bulletproof car that was still sitting in Texas a few years ago because it's against the law to ship a bulletproof car to Nigeria. So.
It's probably fairly expensive.
Yeah, right, yeah, but the original car wasn't. Making it bulletproof was very expensive. And what's funny, so when you watch TV FBI, this is what they don't show you. Debbie sitting at her desk going through thousands of bank records trying to make nice flow charts.
It's not quite as exciting.
I know, right? You know, if my life was Jack Bauer in 24, the first hour and a half is me driving to D.C. So, proving that this is corruption, I used to get a phone call every time this aircraft took off and landed. So at 2 in the morning, my phone would go off and they'd go, Agent Lapravat, this is Charlie 599er, aircraft has landed in Malta. I'm like, thank you. I go back to bed. I write down Malta and I go back to bed. But I traced it because I'm waiting for it to land someplace the United States could seize it. Who would honor a U.S. seizure warrant? So they didn't need us. Nigeria pushed for this, and Canada was able to seize it, like what, Lanre, a year and a half ago? Year? Yeah. When it landed, I think it landed someplace else, and then in Dubai, and it took off.
In Ireland.
Yes.
Moved from Dubai to Ireland and then.
Yeah. And so when it landed in Canada, the Canadians seized it. So that's a very good thing. And they seized it again as the proceeds of money laundering and bribery. So now Shell, Eni, they are charged in Italy with this $1.1 billion deal, because the reason Italy opened their investigation is because Fabio De Pasquale, the prosecutor in Italy, was up on listening to like what we would call in the United States a T3, a Title III. It's an electronic intercept, like when you're tape recording your bad guys' conversations. And in a conversation, he heard, oh my God, we have to take care of Fortunato. And like Fortunato was Goodluck Jonathan, the president of Nigeria. So he's like, oh my gosh, I'm picking up information about a bribery paid to Nigerian officials out of this Italian money. He brings the case in 2017. I get a phone call, Debbie, will you testify? So I did. I testified in Milan via video. I always laugh. They'll fly me to Bangladesh or Chad. No one wanted to fly me to Milan. So I testified by video and to my tracing, those flow charts, and I mean, there was just so much evidence, and then they get acquitted. And we feel strongly that it was bribery of the judiciary in Italy, because Eni is their largest oil company. It has a lot of power and influential people. And so we are trying to see what can be done. And this is some of the fallout. When people talk about, it's very dangerous what people do to investigate high-level political corruption in foreign countries. But Lanre took the evidence that was presented in Italy and tried to make it public in Nigeria, and he was falsely charged by, I think they charged you with cyber stalking for going after the former Attorney General, Mohamed Adoke. And by the way, when I was investigating Nigerian corruption, I wanted records out of Nigeria, but Mohamed Adoke was the AG at that time, and my request would go to him from our Ministry of Justice to their Ministry of Justice. So I waited until Goodluck Jonathan was out of power, because I couldn't, he's not going to give me records incriminating himself. He, by the way, has the money he made, which doesn't fit with the salary of an attorney general. He has a very lovely home in Dubai. And so Lanre was falsely accused of that. Then Fabio, as Rick said, Fabio and his assistant prosecutor have been falsely charged in Italy. Why? Because it removed them from the appeal process. And then lastly, Lanre woke up, and he can, it's his life, but he woke up with a shotgun to his head and 5 armed gunmen in his house, and thank God is here to tell the tale. But these are the tactics of a company like Shell and ENI and to make this case go away, and our efforts here today is to make sure that this case does not go away. So thanks to Rick and Steve, and Landre and Simon and other people behind the scenes, we would like the United States to reopen its investigation into OPL 245.
Open for discussion.
Yeah, okay, I think I should just briefly, and then Simon too will just.
Okay.
Thank you very much, Deborah, and I think this, I thought you were just actually going to talk about the film. I didn't know I was going to feature even with my photograph there. So, but in the real sense, I'm going to start from where Deb actually ended, which is simply, it is impossible for the United States to have invested heavily in the investigation of Deb into that haste of what she said worth about $20 billion, and the companies only paid 1.1 billion, 1.3 billion for the license, and eventually 1.1 billion of that was stolen by people who have connection with the oil company, people who are officials of the Nigerian government, and at the end of the day, thank God the investigation and prosecution by the United States government was just suspended, so what was suspended can be reactivated. So for us, it is about the US opening what it has suspended before now to then go into bringing back what Deb did and before she left office. So even, I'm not sure, maybe you need to be recalled back to continue where you stopped before you went away from office. And that is why we think that it will require the effort of civil society organization and the media in the United States. We've just written a letter which Rick mentioned to the Attorney General of the United States to actually do this reopening, which was signed by quite a number of some of our civil society partners. And we can really go into the details of how we got here in the last almost 10 years. We've got Corner House, one of the partners in the UK, and we have the Common in Italy, where we've actually gone beyond what you see in Italy, as far back also to Portugal. We've been to the Netherlands, we've been to Switzerland, we had it in the UK, and it's ongoing in Nigeria, and we're hoping that Nigeria might actually be able to convict some of the people and the company involved, at least so that something can actually come from something good might actually come from where we actually call the fantastically corrupt country, like the former Prime Minister of the United States actually called Nigeria and I think Pakistan. So where Italy has failed to deliver justice and has also departed from the provisions of the OECD Convention on Anti-Bribery Law to the extent that it was also recommended that the judges of the Italian judiciary should actually also undergo some measure of re-education and tutorial to understand what is required of Italy. So for us, just this is the little background that we can actually provide within little time, but the most important thing for us is to ensure that this does not go down the drain. The number of years invested in this case, the effort of people like Deb, the ones that other people that are actually also suffering some measure of persecution with Fabio, the former EFCC chairman in Nigeria, Ibrahim Magu, also became a victim of these circumstances where he was removed from office, he was detained, and he was almost also losing his due promotion in office as a mark of his consistency and also devotion to the work. I think, where's Farouk? So that's the representative of the current EFCC chairman, and I can really give a huge salute to the EFCC for those who would know how much they actually tenaciously investigated the case in Nigeria at the point when even our current Attorney General of the Federation was compromised, and he wrote to the president to say, no, I think you should stop the EFCC from the further investigation of this case. Magu wrote a counter. I mean, that is very rare because the Ministry of Justice is the supervisory ministry for EFCC, wrote a counter memo to the president and said, we have more than sufficient evidence for us to proceed with this investigation and prosecution of the people that are involved. And they actually charged both Eni and Shell, their subsidiaries in Nigeria, their officials as well, to the Nigerian court, of course, because of the so-called influence and power of the developed countries. These individuals ran into their country, and it's becoming extremely difficult to bring them to Nigeria to stand, trial. But if Nigeria is unable to bring them to trial, we think the US, as the superpower of the big brothers, should be able to reopen this investigation where others have failed and ensure that justice is done. And to the victims of corruption, they will have reasons to thank the system. Thank you very much.
Gosh, what to add after that? I suppose a couple of things, just really quick. After, 24, 5 years now of investigating oil and gas industry corruption in many parts of the world, for me, although I've seen lots of egregious cases, I think this case really just takes the biscuit. Just to sum it up, it's effectively $1 billion bung to the top entourage of the state during Goodluck Jonathan's presidency. And what they got back in return, had the block been developed at the Shell estimated price, which they assumed in their calculations to go ahead, that were part of their the fiscal terms, they were so egregious that the Nigerian state stood to lose, on the basis of $70 a barrel, something like, I can't remember the figures now, $4 to $5 billion, which at the time we estimated was something like twice the combined health care and education budget for Nigeria in 2015. So that gives you a little, I think it's good to link it back to consequence. I was on a panel earlier about the role of oil traders in the Congo. If any of you were in the room and watched that film, it was pretty raw stuff and going into consequence. So I just wanted to bring that back in the context of here. The consequences are really serious, and we need to do something about it. So we, as others have said, we've pursued this now for 9, 10 years. It'll be 10 years this year coming, I think. And if you'd sat in the court and listened to what we did, after, as Rick was saying, the raid on Shell headquarters produced 90,000 documents, and the whole various interviews and the process of the court process and the evidence that came out as a result of that. When we came to the acquittal, it was like, were you judges sitting in the same room we've been in for the last 2 years? It was profoundly shocking. And then the other machinations that have happened since are equally profoundly shocking. And I can only describe them as a case of corruption fighting back. And we're almost now in a phase where it feels like there are some examples being made by those who are on the receiving end of these investigations and prosecutions to let everyone know what happens if you dare to do this. So as we've heard already, we now have the head of the anti-corruption unit in the Milan Public Prosecutor's Office, plus his deputy who worked on this case, so their names were up there earlier, facing an investigation and potential prosecution. They're going to be before a judge in January in the most extraordinary circumstances. And in my honest personal belief, based on the material we've been privy to see, and in the absence of a better explanation, I've really tried to find one, is there's no other explanation other than they were targeted deliberately to discredit them so they could not run their appeal. And the reason they wanted them not to run their appeal is because those on the receiving end of the prosecution could not guarantee the same result would happen with another judge. They had to remove the prosecutors. And so they rolled in a separate prosecutor who couldn't have been more spectacularly chosen to fail in the task. In fact, they didn't even start the task. They rolled up and didn't even contest the case for a few days and then perhaps surrender because the odds were against them. They did nothing. They stood up and castigated the original prosecutors. They said, we can't understand, this person said, we can't understand why we spend public money on this. Well, Italy was obliged to as part of its obligations under the OECD Convention. And so the end result is what we have today. A case that is the third in a row, which we believe was fabricated, and an attempt to remove the prosecutor to stop that being reversed, and that is still underway. That's completely unacceptable. Because the alternative of doing nothing is we currently now have Italy, Europe's fourth economy, essentially, which is not, by the way, an endorsement of lots of other European states who fail in other ways, but we essentially have Italy where if any of us wanted to do a dodgy deal somewhere, we could just set up a company, and unless we were dumb enough to write down our agreement to bribe someone, if anyone here has investigated corruption, knows anyone who wrote down an agreement to bribe, I haven't met anyone who's done that. But unless we were stupid enough to do that and the prosecutors got hold of it, basically you can't be convicted. That's just totally unacceptable. So I'm fully with what Lamre said. The judges, if that's their interpretation of the convention, need to go back to re-education camp. I mean, sorry to be rude about it. They objected very loudly to the recommendations from the OECD working group, who have also found that Italy has fallen out of compliance. But that's not good enough. A petulant no isn't good enough. Someone needs to do something about it. And we think the best way that can be addressed is for the United States now to pick up the mantle and reboot its investigation. It always said it would, depending on what the outcome of these other cases, and properly go after those protagonists. There's just no question from the evidence that people need to be held to account. And right now they're going to get away with it possibly. So this is our call. And anyone out there who wishes to sign up and support or has bright ideas about how to see that progress to some kind of successful start, we'd love to hear from them. Thanks.
And now we'd love to hear from those of you in the audience, either that can augment and add to the comments from our speakers, or who have questions about what's been said. One, and then first, second, third. Okay. And maybe we'll take 3 questions and then have them address it all. So, there you go.
Thanks so much, Franziska Christen, lawyer in private practice in London. Would you not immediately run into a double jeopardy argument? How do you get over that if there's a first instance acquittal?
Okay.
What were the peculiarities of Sani Abacha's death? You said that he died under interesting circumstances. What were the interesting circumstances?
Deb will describe in great detail. And then...
How does the U.S. claim jurisdiction over this case? Did some of the money flow through the U.S.?
Okay. Who wants to...
I'll do 2 and 3.
Do you want me to do 1? Double jeopardy. There is no such concept in international law. It is in the United States, if the state of New York tries you for homicide and acquits you, California can't try you for the same case. Likewise, if a member of the European Union tries you for bribery and acquits you, for example, the Netherlands, because of the Italian acquittal, but of course the United States is not part of the European Union, so there is no such double jeopardy. And interestingly, there are individuals in Shell who were not charged and tried in Italy who may soon find themselves in a Dutch court, since they're Shell employees and they're subject to the law of the Netherlands. Do you want to do two and jurisdiction? Or no, you're doing the Sunny Abacha.
That's two.
If there anyone that's under 18, would you please leave the room now?
I think in addition to the double jeopardy thing, it's also important to mention that that also came up. So the question was right, because the Dutch actually dropped the investigation, which is very bizarre, because the Dutch already indicated to Shell that there are prima facie evidence to prosecute Shell, while even the trial was on in Italy. But unfortunately, Shell went to court to stall the trial using the lawyer-client privileges, because some of the evidence were like email, between CEO to internal lawyers of Shell, not external lawyers. So Shell was trying to use that as a basis of clients, lawyer privileges. But unfortunately went to court, lost at the court of first instance, appealed, lost at the other appeal, and lost throughout in the Netherlands. At the time when the Dutch was expected to proceed, the acquittal happened in Italy. Rather than, like Rick said, rather than Shell now going ahead, the Dutch going ahead with some of the other charges that were not even related in Italy, it decided to dump everything, including a case where Shell itself reported its own staff to the Dutch prosecutor for some measure of suspicious cases of bribery. And for that reason, we are also challenging the Dutch prosecutors on that action through some of the means available within the judicial system of the Netherlands. But I think that does not apply in the case of the United States. The only thing that is like a constraint in the United States is that of the statute of limitation, which says about 5 years after a criminal action. And that is actually also a major challenge within the United States, also criminal administration. Corruption is not the same thing like normal crime. You might not even detect it in 10 years. So, meaning if you detect in 5 years after, you can prosecute it. And so, I think for those who are stakeholders within the judicial criminal system in the US, this is something to start pursuing for a change to ensure that criminals don't escape under the whole law of the statute of limitation.
Deb, are you going to come back with the, Oh, okay. Because we're all waiting
just really,
to hear about
really,
how
really
Sunny
quick.
Abacha died.
Sorry to keep you from your adult entertainment. What was I going to say? Yeah, I mean, Shell can do all the Stalingrad defense it likes, but the fact of the matter is the Dutch and Italian police showed up at the headquarters and they raided the CEO's office and the chief financial officer's office and various other people's offices, and they took away 90,000 documents, and many of them have leaked or have now become public as a consequence of the court of first instance. So my recommendation for anyone who doubts that there is anything applicable, regardless of whether it's legally applicable or not, is go read these emails, because they're all up there in the public domain, and you can see precisely what they knew. They not only knew that money would be distributed, the only thing I would accept that they didn't know is precisely how much the different protagonists would get. Would so-and-so get $2,365,000.24? No idea, sure, they didn't. But did they know there would be wide distribution amongst so-called politically exposed people and affiliates? Absolutely they knew. They knew who all the protagonists were. There's a whole load of this. This is where we get into the due diligence process as well. There's a sort of farcical process of due diligence playing an enabling role. So we have this whole debate in some of the documentation about, oh, well, we did our due diligence and we couldn't quite tell, that Dana Tete was the owner of this company. And it's just like, come on. There isn't a document that says he's the owner of this company. But as early as 2000, it was widely known that he was the owner of the company. And essentially there he was as minister, and he gave himself the state asset. So, you know, some of these things are just beyond common sense. And so, yeah, perhaps I'll leave it with that. So, you know, let's see where this goes in terms of the double jeopardy thing. But just to sum up on the Netherlands bit, there are slightly different charges, there is different and additional evidence, and there are different indictees, and they include also the previous CEO, who knew. And they were all involved in a process where they helped design, or in some cases agreed to, the result of the design of the mechanism by which they could bypass the money going into the Treasury. And they all knew about that. So
Now the part we're all waiting for.
Yeah, so it's interesting. Sani Abacha was the president of Nigeria until he died in office in, I think it was June or July? 1998, yes. While he was president, though, he took 2.63 billion straight out of state coffers and another 2.4 billion bribes, kickbacks, and extortion schemes. That was another case at the FBI. But when he died allegedly in the company of 3 Indian prostitutes. And some say it was a Viagra-related heart attack. Others believe that the prostitutes were paid to give him poison. So either way, that was the scenario.
It was not a movie for young people to watch.
You won't see it on the Hallmark Channel. And Louise, to your question, from the very beginning, from the first transfer of 1.1 billion from Italy into the bank account at JP Morgan Chase in the UK, that transfer of 1.1 billion hit 2 US banks in that stuff. Then when it left to go to Italy, and then, the Swiss bank, it came back. Hit 2 on the way, hit 2 on the back. Then it went to go to Lebanon, 2 on the way, hit 2 U.S. correspondent banks, hit it on the way back. But then, if you look on my flow charts, then a great deal of that money came to the United States. The Bombardier was purchased in the United States and registered in Oklahoma. The vehicle that was purchased in Texas that was made into an armored vehicle was purchased in Texas. And so I was able to trace the flow of millions of dollars, not only to and through U.S. banks, but into entities and businesses within the United States. But even the initial 1.1 billion transfer would have given the United States venue because it moves through U.S. financial institutions, therefore affecting U.S. commerce.
And
So the mere fact you're transferring from 2 foreign banks goes to New York, that's sufficient enough?
that is the Department of Justice's position that has prevailed, I believe, in one district court.
No, every single case I had.
But it's not. But they were pleased. They weren't tried. The department's
well, there were
been,
civil forfeiture cases.
Yeah, right. But the
and,
department on the criminal side for jurisdiction has been. There's also a due process issue of how much you got to touch the U.S. in order to.
Yeah.
Be
So I mean, I will say, like,
jurisdiction.
if it's one transfer, the U.S. would probably choose not to go after that. But in most cases, one transaction could hit the 3 times at least. So if you bank in Dubai and you're sending it to me in Switzerland, it's going to hit Dubai's bank in New York City Bank for further credit to UBS New York for further credit to UBS Switzerland. It also probably cleared through the Federal Reserve Bank or CHIPS clearinghouse. So on one transaction, there can be 3 interactions with U.S. facilities.
And I believe as well, both ENI and Shell were any company that issues securities on an American exchange, debt or equity, is an issuer for purposes of the Foreign Corrupt Practices Act, and therefore bribing a foreign public official brings them within the reach of the FCPA.
Yeah, I mean, if you look at Siemens wished to be on the New York Stock Exchange, so they came forward and said, we bribed 137 countries, and this is who we bribed, and this is how we paid them, which was very beneficial to my investigations.
And I think also this year or last year, there's a Nigerian cyber criminal who was arrested in Dubai. It's actually called Och Poppy. he was arrested by the FBI for the cybercrime that was committed against some Kuwaitis in actually Dubai. The only reason FBI got involved and got him arrested was because it was used actually dollars. It was in dollars that was used for the cybercrime. No, it was not on the American soil. It was not through the US bank, but because it was actually because the US dollars. That was the basis of the transfer. He was arrested in Dubai and brought into the US for prosecution.
Can I add a political dimension as well? We've been here this week, and the administration has been talking brilliantly about, it's one of their number one priorities to deal with corruption, to have a credible anti-corruption strategy. And to have an international credible anti-corruption strategy, it seems to me you have to have a functioning international architecture. Now, we all know that that doesn't work in lots of places, but surely it should be working in places you could expect it to work. So there's one element there which I think creates a political imperative to intervene. And the best way to start doing that, I think, would be to prosecute these companies who've kind of gotten away with it in Italy. The other thing I would say, which sort of adds to the politics of this, is both companies were subject to a deferred prosecution agreement with the DOJ for previous corruption cases in Nigeria. And I remember the first AGM I went to when Paolo Scaroni was the then CEO. He was replaced by Mr. Descalzi. Both of these two were on trial and faced potential jail terms had they been convicted. And I remember standing up there at the first AGM when just before I had the chance to ask some embarrassing questions, and he was essentially boasting to the AGM audience, to the investors, that he was now in charge of the subcommittee of their board that was responsible for implementing all their due diligence and control over their anti-corruption strategy, which they were required to do as part of the condition for not being prosecuted by the DOJ. And I had to say in my first sort of preamble before the 17 forensic nasty questions, one of which included about that wiretap phone call, that I didn't actually think his committee was doing a very good job. And that's because he failed to mention his own involvement, plus his other top executives, in their own direct negotiation with Mr. Atete, who they knew or should have known had handed himself a piece of Nigerian offshore asset. So, it becomes farcical, I think, where you can have a tick box system where you don't get prosecuted in lieu of doing X, Y, and Z. And when you look at what X, Y, and Z actually is, you get to say, yeah, I'm doing this, tick. In the meantime, you're busy negotiating your next corrupt deal. And I put it that way because there's no credible intellectual argument to suggest that any of the top negotiating people who were both directly and indirectly meeting with Atete to work out how much to pay, they cannot credibly stand up and say they didn't know who he was, or that they didn't know that he had a substantial role in the company and, frankly, that he owned it. In fact, Eni's internal due diligence said, we can't find any documentation to show he owned us, but everyone we speak to tells us he did. So what do? Oh, well, we'll just do a deal with him anyway. I mean, at a certain point, it's just not credible. And therefore, we need to have the political will to close these types of inadequate systems.
So we have one back there and one in the front.
So thank you very much. So my question is this, so what's the end game? So say we win there's an appeal in Italy and we win, or there's a new case in America. What happens with OPL 245? What happens, who exactly are we trying to bring to book? What's the end game?
Good. And we have Luis? Oh, I'm sorry.
Hi, Bonnie Polivka, Tecnologio de Monterrey in Mexico. I think this is a really good example of the limits of the international conventions, because Italy got a really severe scolding from the OECD. But how can we move toward giving Italy a timeout or something that will really convince countries that they need to enforce these commitments that they've made. And then my second question is about the role of the United States. Does the U.S. actually have the will and the resources to reopen a case like this, or a Mexican case that's close to my heart, that General Cienfuegos, who was arrested on U.S. soil for connections to organized crime, but then he was extradited to Mexico, where with all of the evidence turned over, and the charges were promptly dropped there, and the case hasn't been picked up in the U.S. again. So, you know, the U.S. has been a watchdog, but how much can and will the U.S. do in cases like this?
Simon, you want to speak to the U.S.?
Seem to work. Does it work? Oh, does it work? Yeah. Gosh, I can't read the mind of DOJ. We obviously have sent this thing in. I would hope that they would see this as one of the largest, because let's face it here, when did you last hear two parent companies, two big parent oil companies, very significant oil companies in the history of big oil and how it has gone around and corrupted the politics of the world? When did you hear about those parent companies being on trial? And when did you hear about their highest level executives plus all the middle guys on trial? The evidence was very clear. So my message to that is, are we serious about an international anti-corruption effort or not? And we believe there are grounds to suggest the statute of limitations has not, there are grounds to suggest it should be extended and can be considered as extended, and therefore there are grounds to prosecute. And this is a really iconic case, and I think there's another part of the politics there, which is it's about sending messages. No more. You do this, you steal the healthcare budget and the education budget of a country, for a whole year. There should be a consequence, and that sort of partly answers your question about what's the end game. In my mind, the end game should be that the penalty should be commensurate with the crime. We were talking about this before. Patrick, my colleague who's just sitting in the audience, you might correct me, Patrick, you met an investor who said something like the penalty before it really gets noted, and especially amongst investors, has to be a substantial percentage, and I forget what that figure was, of the stock value of the company. I suppose that's the right way of saying it, before we move beyond what would be considered the cost of doing business. Because let's face it, the statistical likelihood of being nailed is not very high. I've gone over 25 years from starting my work to thinking, wow, this is a corrupt industry, but I meet lots of nice people who are trying to do their best. And, probably there's a corrupt deal here and one here, but this is probably okay. I don't think that anymore. I actually think I was too naive. I actually think the oil industry is a profoundly corrupt industry and has been throughout. And maybe that makes me very naive, but my start point now is to show me the deal that isn't corrupt rather than the other side. So my point really is that this isn't just any old deal. This is one where we have the top level people who were involved in designing the deal, and they knew. So if we can't hold them to account for this, please tell me how we can hold them to account. So I'd stop with that.
I think what has also happened so far to the OPL 245, there's a timeline which is 10 years to have that OPL converted to OML under normal circumstances and within the law. Interestingly, it was awarded in 2011, and it was meant to be converted to OML in 2021, but any applied to the Nigerian government to actually have the conversion from OML. But the groups concerned, and my group, my organization, Global Witness, Corner House, and then also Recommon, wrote to the Nigerian government and said, you can't actually convert the license because it's already subject of litigation in Italy, in Nigeria, and for that reason, it's already declared almost like a proceeds of crime, so you can't have it converted. And the Nigerian government actually, for once, wrote back to us to say they are not taking any decision on it until all the cases are decided. And the same way they wrote to Eni to say we're going to suspend any action on the conversion pending the disposal of the cases in Italy, in London, and the rest of that. Interestingly, the OPL 245 expired legally in March 2021. So as it is now, legally speaking, the license is lost by Eni to Nigeria. But there are efforts which Eni has already approached the International Center for Settlement of Investment Dispute at the World Bank, trying to use the World Bank and these mechanisms to compel Nigeria to do the conversion and reactivate it. And we have also initiated process of challenging that the ICSID and the World Bank cannot actually be used by some of these big multinational companies to legitimize what is already declared some kind of, corrupt transactions and dealings. So as it is legally speaking, the OPL 245 is lost by Eni, and we want to make sure that it remains that. So if we can get the United States to also continue the process like we said, it will make it extremely difficult for ICSID to be used as a tool for legitimizing the corrupt deal.
I'm always about the money. So, I would also, a civil forfeiture action could be filed in the United States to try to recover some of it. It is a 10-year-old case, which means a lot of that money has dissipated. They're getting, like, $54 million bought that aircraft. It would probably sell at auction for $30 million. Plus there's upkeep expenses. But we know that the former Attorney General has a place in Dubai. I would see if that is feasible, if it's directly traceable to these funds, which it probably is. And we'd see the United States would have the ability to work and try to recover some of the money for the government of Nigeria.
I can add a bit on the case you mentioned involving Mexico. Those others may not know. He had been head of the armed forces, and then he was Minister of Defense. He was senior Mexican official, and then he was in the U.S., and he was arrested for his involvement in major drug trafficking. And then suddenly, the Attorney General under the last administration said, oh gosh, we're going to send him back to Mexico. They've promised to take care of this case. Well, he was sent back, and instead of being prosecuted, was released. And now, the little part I can add is a Mexican NGO decided under Mexican law, an NGO can push the government and take some steps to get a prosecution of a suspect underway. And they were beginning to prepare the papers. The people that run this NGO are definitely upper middle or upper class Mexicans. They're, part of the elite. And they were preparing the papers, and two people from the security services came along and suggested to them it would be extremely unhealthy for them and their family to pursue the case. And I asked, what did you do? We immediately dropped the case. And that always hit me because Mexico is kind of on the way up, and they're our U.S. neighbor, and you're beginning to think things. And I just try to imagine, gee, I'm upper middle class guy in Washington, D.C. I just don't think the FBI, maybe I'm wrong, but I don't think the FBI would visit me one day and say, gee, if you keep doing that, we're going to kill you and your family. As far as I know, nor would the CIA or any of our other security forces. And so it reminds me I live in an environment somewhat different than many people in the world live in, right? And the U.S. can do what it can do, and years ago I was in a meeting with the first time a head of state or former head of state in Latin America was ever prosecuted for corruption for anything was Bolaños in Nicaragua. And I knew the young prosecutor had put together the case, and he had some pretty strong evidence, but he had no confidence in the courts of Nicaragua since the guy had picked all the judges. And he asked me just sort of, well, could I borrow one of your courts to try the case? And I said, you know, I can't really rent out American courts. It's hard to find somebody that, you know, sign a lease with. But figure out a U.S. legal offense, money laundering, bribery, bank fraud, and bring the evidence to the U.S. and particularly now with the President Biden's new international anti-corruption policy, you'll get sympathetic ear for pursuing the case in the U.S. And that's that's the best we can do. And of course, you know, there were the dismissal of the two cases involving the Mexican Social Security Administration on forum non-convenient grounds, which was very disappointing. The Mexican Social Security Administration, one of its employees was bribed by, a couple of its employees were bribed by American healthcare companies to get sales. And they said, hey, we're injured because our employee was bribed, and they brought lawsuits to collect damages. And two U.S. courts of appeals said, yeah, but it'd be better if you tried the case in Mexico, and the courts have discretion to send the case to another jurisdiction. And even the Mexican government had filed an affidavit saying, hey, we're fine if you try the case, the two cases in the U.S. I don't think the two U.S. courts of appeals got the memo from the Biden administration, and we're trying to get the Justice Department to do something about that. But, you know, we push wherever we can push. Yes?
I just have a fact-finding question. I have two small fact-finding questions. Who paid for the raid on Shell headquarters that resulted in 90,000 documents? Who financed it? Yeah, who was?
The raid happened because the Milan Public Prosecutor's Office requested, through a mutual legal assistance request, help from the Dutch law enforcement, and the raid consisted of half Dutch and half Italian police, and they spent nearly 24 hours at Shell's headquarters then in The Hague, and that's what they did. They went through the documentation, carted it off. I'm told, unlike any that has been raided multiple times, that Shell was profoundly shocked. It hasn't happened to them before, which I think says something about the gravity of the case.
But it also shows something about political support and cooperation between Milan prosecutor's office and the Dutch prosecutor's office.
Absolutely, it's part of the EU's cooperation arrangements, and it worked quite well. I mean, they had to have grounds for doing this, and obviously a Dutch, I suppose, I don't know how the system works, I guess a Dutch court must have said that's fine. It was through the formal channels, and they executed it, and that was the material, and that ended up all in the court case.
Okay, and then on a separate note, you said the license has expired in Nigeria. Is the present government, for the exploitation of the OPI 245, isn't the present government of the mindset of trying to
Jerk back the license?
Yeah, to recognize that its expiration?
Yeah,
I'm just trying to figure, I'm in my little detective fantasy here, I'm trying to figure out what we can do to pull the pieces, you know?
Yeah, I mean, of course, the official statement and the official letter to ENI from the Nigerian government is to say the license expired. I mean, well, we're not renewing the license until all the cases are discharged in courts, you know, and the cases are still here and it's still ongoing in Nigeria. Even though the ones in the Netherlands and from part of the journalists and information we also got was that the Dutch prosecutors had visited Nigeria to obtain some documents from the EFCC, which had been assisting with the local investigation and information and stuff. And the Nigerian government is also engaging the ENI at the ICSID level and the World Bank. So going to defend their action there is more or less to say, oh, no, we're standing by our decision. Otherwise, they would have possibly just said, oh, you need not go to the ICSID or World Bank, come and have the license. So it means that they're still going ahead with that.
Do you know which law firm is representing the Nigerian government?
I think it's a law firm in the UK, but it's something that we can actually get that information and then, make it available, Mm-hmm.
Thank you. Fascinating subject. I overheard someone say that the OECD has scolded the Italian court system over its behavior, which then raises perhaps a purely speculative question of, under FATF, can sanction a country and place it on its gray list should a country not be found to sufficiently prosecute money laundering. And that would be an incredible sanction for a country. So one's mind goes down that direction for a moment, and I pose that not necessarily to the FBI, but to the investigative journalists and to our colleague from Nigeria. Just a speculative question. Another speculative question from an unsophisticated audience member. Is there a role for Securities and Exchange Commissions to evaluate the financial and stock positions of companies that are publicly traded should they be found to be engaging in nefarious acts? Nefarious, it's a word.
And we had,
Good afternoon. My own is just to add a small update on the cases that are going on in Nigerian courts. My name is Farouk Dogondaji. I represent the executive chairman of the Economic and Financial Crimes Commission, one of the anti-corruption agency in Nigeria. We have 3 cases ongoing at the time I'm talking about now. Federal High Court, 2 cases bordering on money laundering, and the FCT High Court, where we charged the former Attorney General and some other 7 people together. So at the moment, in each case, we have taken prosecution witnesses 6, 7, 6, respectively. That is 2, 6 in the Federal High Court, 7 in the Federal High Court, and 6 in the FCT High Court at the moment. And soon, we round off a line of evidence and open defense. The provision of AJA, that is the Administration of Criminal Justice Acts, provides that you can try person is absential if you have already taken his plea before he ran away. So we're on, and the Nigerian government is committed toward that. Thank you very much.
do you want me to take a hit? The Financial Action Task Force's 40 recommendations on preventing the financing of terrorism and money laundering have been perhaps the most significant international agreement that we've ever seen in terms of the ability to enforce it, because, well, first, we don't enforce it against, for example, the US, which is not in compliance with all the recommendations. But if you're a poor country, and you're in Africa in particular, or you're North Korea or whatever, we enforce it against you. And we can do so by saying, gee, you can't, if another country wants to trade with you, they have to go to extra steps to make sure they're not trading with somebody that has dirty money. The additional costs imposed on firms that want to do business with countries on the gray list, the list of people that aren't fully complying with status, are such that countries will do whatever they can to get off that list. We could, I suppose, amend the OECD Anti-Bribery Convention to say if we find you're not enforcing it vigorously, we'll do something to you. What we would do to you, it's hard saying we won't trade with you unless you take extra steps. But of course, it takes a unanimous agreement to amend the OECD Anti-Bribery Convention, and it's all rich countries, and they're not just going to do that. As I say, it's easier to beat up on poor countries via the FATF or whatever. But it's still, FATF is better than no FATF. And there are, of course, provisions in the securities, at least in the American Securities Act and the requirement in the OECD Anti-Bribery Convention for the other 43 signatories that they have what we call in the United States books and records provisions, which means you can't hide wrongdoing by not keeping accurate books and records of how you're spending your money. So you can't call a $100,000 bribe or a $1.1 million bribe a consulting fee. You can't say, oh, consulting fee, Rick Messick, $1 billion, much as I would like to receive that as a consultant. It has to be bribed to obtain, a vote in the Senate or whatever. That's about as close as we've gotten on that. But there are, of course, cases in the United States where shareholders have tried to bring actions against directors for not properly supervising the employees that ended up getting caught doing wrongdoing and therefore cost the corporation money. Those sometimes work, oftentimes don't. Oh, yes.
Thank you for the really informative discussions. I was wondering, are there any other jurisdictions that you would see as fallback options in case the US is not acting? I mean, you mentioned, I think there were UK bank accounts, other avenues that you would see, not preferred ones, but if the US is not acting, so that this is not the end of the story. Thank you.
Well, we mentioned the Netherlands before, different crimes, different characters, additional evidence. I would say it's interesting to note that the Netherlands is in support of an international anti-corruption court. Great. But to let this one go, and I have to... Yeah, it doesn't, it's a little bit inconsistent, I think, letting this one go. And the reason I raise that in that context is we're pretty concerned that at least on 2 occasions, and possibly a third, which I certainly can't talk about, there may have been attempts to interfere with procedure. I won't say more than that, maybe at the moment. I don't know if you want to say anything more. But they were sufficiently worrying to make us wonder whether there were sort of, shall we say, corrupt intents coming from outside to shut things down. I don't for a minute point my finger at the Dutch investigators or prosecutors at all in that. I think they were on the receiving end of such pressures. So it's a big concern, I think, to have a state signing up to that, and that's fantastic. If that's what they want to do, I totally support them going to help set up this court. But I think they should be mindful of the fact that they shouldn't just have this ended like this, especially in the questionable idea that this was a case of double jeopardy, because we just don't think it was.
I would also, as a plan B or C, I mean, obviously, the ideal situation would be for DOJ to reopen the previous investigation. But I worked in an investigation where a Canadian company paid bribes to obtain an oil drilling license in Bangladesh, and the field ended up blowing up because the company was not qualified to have the drilling contract. And they ended up revoking the contract and had to go to the International Arbitration Court. And I ended up testifying for Bangladesh in that court with the FBI's permission. And although they didn't win in that, they came back and they sued them civilly, and then they won in the civil. So I mean, there are other options, but our primary option and our best bet, I think, initially would be to get DOJ to take action.
We have a
And I think, yeah, sorry, in addition to that, just like you said, the Nigerian government is already also on a civil case in Italy. They joined, they were part of the prosecution process as an injured party in the case. So when the appeal was withdrawn by the prosecutor in Italy, the Nigerian government lawyer has gone ahead to actually sue for the civil angle to get some civil claims in Italy. So you were right when you said you couldn't proceed with the former Attorney General, in FBI because you were not going to get anything. We remember we were in Portugal in 2017-18. And we discovered that when HEDA moved $1 million to Portugal with a bid to actually get the golden visa. I mean, Portugal had that policy where you can, and he went with a girlfriend, like an 18-year-old girlfriend, to actually get the golden visa. And the Portuguese government actually froze the money. And wanted information from Adoke as the Attorney General, and a letter was written under MLA to say, we have this money that has just moved into Portugal. We suspect it's actually some form of proceeds of crime with suspicious transaction, and we would want you to confirm, with this. He never replied to the MLA. Not only that, by the time we got to Portugal and the Portuguese government said, the process is still on. There's a limit to how much the law allows us to, freeze the money. We had to release it. But Itete immediately ran away without actually obtaining the golden visa when the money was frozen. By the time we got back to Nigeria and got the EFCC to try and trace the MLA, there was nothing in the file. The file disappeared. So it is still not impossible that some fin can actually also be reactivated in Portugal because, like I said, $1 million as part of that money actually also moved through the Portuguese financial system.
Should Shell and Eni happen to be as influential in US as they are in Europe, talking about the ideas of what to do, do you think that documentaries such as the one we saw recently today is an effective tool? And even regardless whether DOJ will or will not react in the way we hope?
Yes, I think that would really be good. In fact, those who can actually write and also produce books are also encouraged to follow up on what people like Patrick already did, talking about bad people, and think now we should also be talking about bad deals and bad companies, to have books written around this, and the documentaries like you mentioned would really be fantastic. It's been really tough. It's been capital intensive. We actually paid a whole lot doing some, economic and financial analysis of the deal, getting lawyers to get action done. There's quite a number of them are not just pro bono services, because you need to get also lawyers who are top of their job to match up to these characters. And I think part of the thing, like you said, that's a great fear for us. I mean, one is that we don't want the situation where all we would get from the United States is just some form of sanction where the companies are made to pay some fines and penalties, and then they get a slap on the wrist and asked to go and say no more. No, we really want a situation where individuals associated with the corrupt deals are also brought to book. I mean, companies don't commit crime. It is just the elite's way of escaping with blue murder that they name the companies. People use the cover of the company to commit many of these atrocities, number one. Number two, we really want to see how we can also get the political angles of the system to be part of it. So a public congressional hearing would also be very fantastic in the United States. This also should provide an opportunity for people to understand and know what we're talking about, and also the political class should also take interest in that.
Can I just add, after sitting watching oil companies, as I said before, for a long time now, I remind people of the, can't remember her name now, and somebody or other, senior vice president in Shell, who appears in WikiLeaks cables talking about Shell's access and influence in Nigeria. And I'm paraphrasing, I can't remember the exact words now, but words to the effect of, we basically have access to every single department at the very top. We know everything that's going on in the government. The reason I mention that is that was about Nigeria. That should be worrying. In the previous conversation here this week, I talked about when we turned up in Parliament in Brussels, and Shell turned up with 140 lobbyists. And I think, fine, that's legal, but I think it's part of the corruption spectrum. For me, corruption is not just about what is legally proscribed. It is a whole gamut of other things. It's influence peddling, it's reach. And I've also seen that in operation. We all know about this here as well. It's access. And some of the people I've met over the years here who do things for companies and introduce people, it's very clear that the access thing is a problem, and we have to work out what to do about that. Otherwise, the counter-narrative in a debate about public policy is completely drowned. And I think that applies to political will around prosecutions and basically all aspects of political life. So we've got to do something about that. We should be under no illusion about the reach the companies have.
Did I see a hand in?
I'd like to touch on that one bit, though. There's been like 3 documentaries on the Malaysian 1MDB. And because I keep getting called to get interviewed for that. And so, why? Because it paid for the Wolf of Wall Street, because they bought crazy things, and they hired Leonardo DiCaprio to be in The Wolf of Wall Street. The mastermind was dating a Victoria's Secret model and bought her $8 million worth of jewelry. So but in this, obviously, there's threat, intimidation, the use of lawfare, the purchase of $54 million aircraft and armored vehicles. So it's all there if there's a good vehicle to keep this in the limelight, and I think it's as interesting as the Malaysian case.
And we have.
Hi, my name is Maria Cristina. I'm from Brazil, but I live in the United States. I am protected by US because I witness against corruption in Brazil. But I'm helping with the investigation of Brazilians laundering money through real estate here. One of them, for instance, had sonegated, like tax evasion, 7.5 billion reais in Brazil. He has 9 houses in Miami. He lives from one to another in a boat of 100 feet. And nothing happens. It's 3,220 properties in Miami, 1,350 in New York, and 320 in Aspen. So basically, they do Shell, like a Shell company in Panama owns a Shell company, and Doha owns a Shell company, whatever, and then they buy here. But it's crazy, the amount. And then you go to the list of the people who does the biggest tax evasion people in Brazil. They are laundering money here in real estate. So this is something that it's $1.2 billion of tax evasion in Brazil, and the guy is free in Miami. So no. So I want to know, how can we solve this? Because Brazil government, they sit on investigations and they put under the table. It never finishes unless there's a lot of pressure. But the United States goes to the end. And for United States, tax evasion, although for Latin Americans, this is not a crime for Latin Americans. They think it's normal. But here's a big crime. You have Leona Helmsley, you have a lot of people when they do tax evasion. So if you go through American eyes, someone who doesn't declare the property is basically laundering the money in another place. How can we solve this? Because I think once you kind of stop this, it will be easier to make them pay the taxes and all the stuff.
I mean, I can answer that are you telling me that the money that's being invested in all the property in the United States is the proceeds of tax evasion from Brazil? I can tell you right now, the U.S., it doesn't, I'm not agreeing with it, but I'm telling you, like when I seize money through money laundering, it's got to be the proceeds of an SUA, a specified unlawful activity. Tax evasion is not a specified unlawful activity. So even if I wanted to, I worked the Dante case out of Brazil, where like $1 billion or like a lot of...
This guy is called Ricardo Magro. It's a refinaria de manguinhos. It's 1.2 billion.
Yeah, so I went over to Sao Paulo, I got all this information, but and I wasn't able to do anything because it is the proceeds of tax evasion. But if any of those individuals, the money that they're generating in Brazil is any way criminally derived, because they're doing embezzlement, extortion, kidnapping, whatever they're, bribery and kickbacks within Brazil, like the big meat company there, JB. Yeah, because I worked that too. If you can say that any of the properties in the United States derive from criminal activity other than tax evasion, then there's something the United States can do. But if you're only saying that like they earn billions of dollars legitimately, but they just don't want to pay taxes in Brazil, and therefore they're offshoring wealth in the U.S., that they can't, under U.S. law, tax evasion is not a specified unlawful activity.
Under current U.S. law, and there is some movement to, but the problem is that makes it a crime, but in order for the U.S. to prosecute someone for laundering money from abroad, it has to be what Deb called an SUA, specified unlawful activity. And if you look in our statute on 18 U.S.C. 1956 subpart H, just to name a name, you'll see the list of specified unlawful activities, and tax evasion is not one of them. Now, there's been discussion, there may be a draft bill now in Congress to add tax evasion to make it a specified unlawful activity, so that if it's a criminal violation in Brazil, it could be money laundering violation here, but not yet. And of course, this sort of goes back to this issue of, is the U.S. going to prosecute everything? and there's an argument, well, look, if no one else will and we've got the resources, fine. And then there's always a discomfort that it's the imperial big dog and gosh, shouldn't other countries be picking up the slack, and is the U.S. too far out in front?
Maybe the U.S. can create a bill that they charge like a fine on people who leave this year.
Would it be retroactive then?
Oh, laws can always be retroactive. But they can be. I once wrote a retroactive law, so it's Scalia, a very conservative guy, gives you a lot of play in that, in a decision he handed down, 20 years ago now.
I have a partial response to that in the context of our case, and just to bring that whole conversation back to our case, and that is that I honestly think in our case, despite the amazing work by people like Deb and the prosecutors in Milan, the thing wouldn't exist if we as civil society hadn't brought it. And I'm not saying that to put us on a pedestal. I'm saying more it as a reflection of civil society, I think, has a unique role to play in bringing specific cases in key moments that have socio-political context importance. And that's why I would advocate again for this particular case, because if you go back over the history of prosecutions of the oil industry, which has a notorious history of corruption and complicity in everything from assassinations to coup d'etats to bleeding countries dry, there's very little in the way of really holding them to account. There's the odd big fine that you and I might go, ugh, that's big, but it's really the cost of doing business. There's nothing really that I can think of that really stands out as consequential to the point where company bosses might go, no. And that's why I think this is an emblematic case.
Yeah.
Now, whether we end up with a fine because the laws aren't good enough to allow for a fine that's big enough to make it consequential or not, I don't know. But I also think we have to hold the individuals who knew or should have known, and we know knew, to account. And until we do that, we're just going to see repeat jobs. So I think this is a consequential case for that. And it's about sending messages that we, whoever we are, will get you if you start pillaging other states.
And I tell this story a lot. The only time in my life I have ever seen a person faint is when I was a young lawyer. I was working on a lot of cases involving bid rigging and public contracts for roads in the United States. And a senior partner in my law firm was explaining to an executive of a major construction company that the Department of Justice is seeking incarceration for those deeply involved in the case. Now, Mr. Jones, I was the young lawyer in the room. Rick over here is going to be writing a sentencing memo emphasizing what a good citizen you are, and you're a member of the church, and you're giving all this money to charity, right? But given your involvement in the price-fixing conspiracy, I think you should begin to prepare yourself for the possibility. I think he got about that far, and the guy fainted. I mean, he fainted, right? Right in the fancy law firm conference room. So we revived him, right? And he ultimately did a couple of years in a federal penitentiary, you know, one of the ones for Allenwood. It's a sort of a golf club-like penitentiary. But I know I'm just absolutely certain he never fixed a price on a public contract again. I suspect he never crossed the street against a light again. In that series of cases put some 250 executives from construction companies in 21 states in jail for 2-3 years, not by standards a long time, but if you're an executive who's, you know, right, this is a big deal. And as far as we know, as of 2 years ago, a Federal Trade Commission report said, you know, people don't fix prices on roads contracts. We just don't get any complaints and we don't see any evidence. Now we'll see as memories fade if that comes back, but that's the way you do it. You don't, company pays $1 billion, the executive go home at night to their fancy home, right? Executive goes to even a club fed, as they call them in the trade, someplace like Allenwood, where there's no walls, there's just a wire, and they have a library privileges and, you know, this and that and the other. But a couple of years away from your family, I gather, is a rather stiff deterrent.
We have to be able to throw eggs.
Oh, well. Oh, I'm told we have run out of time. So we appreciate very much your time and attention.